It's not in the face! Thank you.
Hello and welcome to Hey, Not the Face with your host, John Nash, and your producer, me, Steffi Haynes. And today we got a lot on our outline. We are going to talk about the big porn industry. Yep, that's right. We certainly are. We are also going to talk about Nick Khan and Lou DiBella and the Saudis and Mark Shapiro. All of these things, even Ronda Rousey. We have a laundry list of things to talk about today. But if you want access to that entire conversation, you're going to need to pick up a paid subscription because about half of our shows end up behind a paywall. So every episode, unless it's a special one, is paywalled at about the halfway point. So smart cookies out there will pick up a paid subscription. Now, John, how the heck are you?
I'm good. I just beat long day at work. Had an excellent lunch there, though. We had a pasta bar for lunch, so that was good. But no, I am just I have Isla the cat. I thought she'd be leaving me alone. My brother is back in LA, my twin brother, so I thought he'd be watching the cat tonight, and apparently she still won't leave me the F alone. So we are stuck.
Oh, here we go. John starts out with "Leave me the F alone," but by the end of the show, you will get the full fuck out of him.
Yeah, yes. I'm censored. Yeah, you give away free. Give away the best stuff free. That's behind the paywall, the full, unedited, uncensored.
John's fuckery is for behind the paywall.
Yes, exactly. You guys got to pay for that for me to drop the F-bomb.
All right, so let's go ahead and get down to brass tacks. First off, we always start the show with if there are any new UFC antitrust updates. Are there?
You know, there is. Nothing amazing, I guess. Nothing massive, but there are updates. So let's talk about them. The first one, probably, I guess the one that we'll do them in order they came out, but there was a minutes order posting from the April 20th, 2026 status conference. So that's the one that was a few weeks, a week and a little over a week back that we had Alessandro Gelki give us an update on. And so this was posted on Pacer, just given the minutes from the hearing. So most of this we discussed. They talked about how there was a forensic examination, how the court's digital forensic analyst Eric Whedon, he participated remotely in the hearing, the status conference, and that the parties were ordered to sign an engagement contract with him by April 28th. So that's ones we will have his findings on May 11th coming up. There were some spoliation issues they talked about. So defendants' discovery vendors, which is Holo Discovery and Concilio, they have to appear at the next conference status and file their own reports, mirroring the format of Whedon's instructions. There's discussion of the phone records where Dana White was personally ordered to request his own phone records from his carrier covering December 10th to present by April 29th, 2026. So he should have done that by now. Other key custodians, Mick Maynard, Sean Shelby, and others must also confirm they've requested or consented to disclosure of their records. There's a search terms and scheduling. They covered the parties that are at an impasse on search terms. They have to submit their proposals on May 11th. And then there's some administration matters concerning, which we didn't talk about all with Alessandro Gelki, that other related new case, the Constantino versus Zuffa case, which, if people recall, was the case that was filed on behalf of fans for the crappy UFC product they've been getting lately. That's seeking potential class action. So there was that, a little bit on that. And so that was the status conference. The next status conference is scheduled for May 18th, 2026, which is going to go through a lot of that stuff. In addition to that, the court had a court order setting out instructions for the court-appointed digital forensics expert, as we mentioned, Mr. Whedon. Phase one, I guess what I should say, the instructions are divided into three phases. Phase one is device identification. The expert must collect basic identifying information from each device, the phone numbers, serial numbers, Apple ID, OS version, things like that, and report those findings to both parties. Phase 2, extraction reporting. The expert performs a full, or I guess called advanced logical, file system extraction on accessible devices and provides the data to the defendants to review for privilege and responsiveness. And then the expert keeps a full image of each device but cannot share it with the plaintiff without the defendant's consent or a court order. For inaccessible devices, the expert may send them to Celebrate for unlocking assistance. And then by May 11, 2026, the expert must submit a report covering iCloud sync logs, app accounts, usernames, message accounts, and data ranges per app, things like that. Passwords are explicitly excluded from the report. I think he'll have them, but he won't share it with the court and the public that way. And then phase 3, confidentiality. The expert is prohibited from disclosing anything learned during the examination unless specifically authorized by these instructions or by a further court order. And so in short, the order sets up a structured, neutral forensic examination of devices relevant to this UFC antitrust litigation with careful controls over what each side can access. And so that was the final document. So that's where we stand currently. It seems like there'll be a pretty big day for the next status conference, May 18th. A lot of things might get settled that day.
Now, I have a question.
Go ahead.
These purveyors of information, these analysts, are they agreed upon? Whoever's going to do that, like these specific companies, are they agreed upon by both sides? How do they? Okay, go ahead.
They're both agreed to. I think this was court ordered, the Whedon one, but yet remember this was several status conferences back. He said we have to come to an agreement to give him a chance to come up with a jointly agreed. Otherwise, the court would. I'm not sure if this was jointly agreed or the court selected this one, but that there's going to be one individual that's going to go through the phone forensic expert, and then there's other group Holo going through like the emails and things like that. So they jointly came to, I think there's a limited number of people that do this, I think. So I'm sure their options weren't, it wasn't like there's a ton of people they could choose from.
Is there a vetting process? What I'm getting at here is, how like in this Ali Revival Act process, a lot of the sponsors of the bill have like history of campaign contributions from TKO and things like that. I'm just wondering if there's a vetting process of these analysts to make sure that there's no links to TKO, Zuffa, what have you.
Yeah, I have no specific knowledge, but my guess is no. And these are figures that's their service is regularly done on behalf of, they regularly do these procedures. And I don't think they have any relationship with the TKO because the last status conference I was at, I believe, if not this figure, one of the other ones was sitting with the plaintiffs.
Okay.
He was their recommendation, and the defendants agreed to him, and so did the court.
Okay. All right. That's just my brain moving in weird circles.
Getting the tinfoil hat on, getting all nervous, getting all paranoid.
But, sometimes there's reason. And boy, these people, especially the way that, we're involved in a spoliation hearing, So,
he left his phone in the car in a black case and couldn't find it. Give the guy a break.
Yeah.
And the nephew stole it before. And then they forgot to turn off their auto delete.
Yeah. And they lost.
And then they don't know what happened to the other
6 phones.
And they forgot to tell the court about their other phone. And then they forgot the whole thing about the signal chat. So it's just common mistakes. Give them a break. Come on. What are you so paranoid about?
All right, let's move on. There is a big porn industry antitrust case that was recently filed. What are the details, and can there be like any parallels drawn between this case and what's going on with the antitrust cases in combat sports and specifically pointing at the UFC?
Well, first of all, this is a chance to say if you thought fighters were getting screwed. Let's get into rim shot there. Here we go.
Get screwed.
There's not much about the antitrust. Well, there's a little bit. The antitrust case is not the first thing that came to mind, but as a quick summary, people are not aware, in California, there is a performer. I guess her name is, I'm looking up, Kenzie Annie sued Vixen Media Group. I didn't know Vixen was still around. The office, I used to work right next to their office. God, the titles of all the brands they have too: Vixen, Blacked, Tushy, and other brands. In May 2023, allegedly the company violated California labor code by misclassifying the performers as independent contractors rather than employees. So the ruling was there was a judge, U.S. District Judge, Sue, certified the case as a class action. So this could potentially cover 767 performers who worked for Vixen between April 20th and the certification date. Then class includes performers who worked under contractor agreements, even through personal loan out LLCs. So another company loaned them to it. So even they're fall into this category. And so what's being claimed, the lawsuit focuses on what's called waiting time penalties, which is under California Labor Code 203. The argument is that these adult performers exercised employee level control. I should say these adult producers, these porno producers, exercise employee level control over performers, who you got to remember are considered independent contractors, by dictating their wardrobe, their partners, the testing schedule, even tattoo and piercings, but never paid them for the off-camera work, like their STD testing, hair and makeup, and costume fittings. And so the plaintiff's expert estimates potential penalties could exceed $421 million. And then so Vixen's defense that failed with the judge rejected all their arguments, including attacks on the porn actress's credibility, her tax filings as a contractor, and her standing as a former, not current contractor. So that's kind of a brief summary. If you read that, there's a lot of things you can take away that kind of maybe apply to MMA fighters. For one, there's long been an argument that MMA fighters should be classified as employees, not independent contractors, right? And under California Labor Code, Section 203, there's a thing called the waiting time penalty, where if you're misclassified, you should be paid for the time you wait around, even though it's supposedly under your contract. So here, they're independent contractors. The porn actors, while they're waiting to do their scenes, perform, they have to do, all that waiting time, especially like, taking their test for their STD testing, which you have to do before you're a porn actor, before you do a scene. That's a requirement in California. Their hair and makeup, all those things, they're claiming that's waiting time they deserve to get paid for. Well, fighters have a lot of things they do in addition to the fight that adds to their time. Fighters have there's the test. The UFC covers them often. Sometimes fighters have to cover their certain tests. There's the entire requirement to show up for the fight week promotional. There's the thing that fighters would have to sit down and sign a ton of posters for free that are sold by the UFC. All this additional labor that's on top of what their basic work they're being hired for as a contractor, which is fighting. And so this might explain, remember we had a whole discussion why the UFC has in their contracts a special provision that prevents fighters from, supposedly forbids fighters from training in the state of California, which I will read to people if they're interested. Here's the basic contractual provision. This little sentence, it says, as it talks about, declares fighters are independent contractors, but in that section it says, fighter additionally agrees that if the fighter chooses to undertake any training activities or preparation for bouts, such activities and or preparation for bouts will not take place in California. I think it's very possible that this rule, this regulation in California is the reason they have that. They do not want fighters claiming when they have signed a bout, which is where they haven't agreed they're going to fight and they get paid. The fear, I think, for the UFC is California law could consider all that labor leading up to the bout as something they should be paid for. And I think someone brought this up to us before, kind of like the minimum wage rule, that time could be accrued as minimum wage. I think this probably explains why they don't want fighters training in California for bouts.
Wow. Okay, let me ask you this. Let's say this thing goes the way of the performers and they win. Could this end up being like, remember the tuna case? Yes. Could this be something that future suits could point to and say, hey, this case over here happened and they ruled in their favor?
Well, future cases, yes, in California, but I don't think it would impact the UFC case. And unfortunately for the UFC fighters, there's a lot of reasons why this case, as interesting it is, and I mean, I guess there's a few possible ways that someone could maybe try to use this case to go after the UFC. But one is UFC doesn't hold many events in California. Mm-hmm. Two is they have that contract provision says you're not supposed to train in California. I don't know if anybody honors that or not. But on top of that, they have their arbitration agreements and class action waivers, right? This is a separate case than the current antitrust case that the UFC had already been filed on the UFC. So those arbitration agreements and class action waivers are being challenged in that case, on the Johnson case specifically. I guess it's the Misha Serkinov case that's challenging on behalf of all fighters that signed arbitration agreements and class action waivers so they can take part in the Johnson case. But that Johnson case was already it was considered an extension of the Lee case. It's already an ongoing case. And so that's why that's being challenged. The Supreme Court has already made it very clear. In fact, they probably made it clear in this case too, sadly enough, the UFC with the United Italian Colors case is that these arbitration agreements and class action waivers would prevent fighters from going to California and filing a class action against the UFC. They would independently have to take these accusations against the UFC and go into arbitration court.
Dang. Okay.
Dang indeed.
I was hoping, you know me.
Yeah, I mean, the other possibility, though, is they could use this potentially in whenever the next administration comes in, if the NLRB wants to do something, but who knows if they will. But there's another problem the UFC fighters are going to have, and this is a big one, we've talked about this before, there was a case called Gross v. Three Rivers in New York, and the appellate court kind of overruled it, but the original ruling standing was that fighters technically can't sue to be employee status because employee status grants you workers' comp. It grants you protections if you get injured on the job. But your basic job is you're saying, I am going in that ring to injure that other person. You've already agreed to that part. And so the only way they ruled, the court ruled in that case, was the only way it works if you are independent contractors. So there is that hurdle as well. So it could be difficult to overcome that. But obviously there's reason to think if there's a reason they don't want fighters training in California, right? So there has to be maybe a possibility. If they're concerned about it, there has to be some possibility that this could apply to UFC fighters, that fighters could take advantage of that law somehow, especially if they trained in California.
What about when they have fights in California and they train all week long up until that point?
Yeah, I mean, that's a possibility too. That's another one. So, but that it's a few fights. So the fewer cards they have in California means there's less fighters possible. And it's a narrower time. It's the time you're in California, where if you were training in California and you made that accusation, it's like my entire training up until the fight should have been covered.
I have another question.
Go ahead. I mean, I don't know if I have the answers because there's still a big question is what they're thinking about with that provision.
What about Zuffa Boxing? What about when they have cards in California? Boxing.
The interesting thing about Zuffa Boxing is Zuffa Boxing contracts, according to I think this is true because we have a couple of those contracts, and I think I went back and spotted this after Thomas Hauser brought it up. Zuffa Boxing contracts have a provision as well that says you cannot train in California.
Okay, but there's so many boxing clubs in California.
There is, and I don't know if anybody's following that rule that they will not train. Well, I think specifically it says you will not train for a bout in California. They don't care if you train in California. They just don't want you training for your bout in California. And I don't know how you get around that if guys keep training or if that's, they expect those guys to go to Vegas and stay at the Performance Institute. So they're not training in California as they prepare for a specific bout.
That is crazy. We're definitely going to need to keep an eye on that.
Yeah, that is one of those kind of mysteries right now that I'm starting to get a sense of what I really think is the reason behind it. But it's wild that they would have that provision in there.
All right, let's move on because there was a release over the last couple of days. The Senate website for the Commerce Committee, they posted a 17-page version of Nick Khan's opening statement from last week. So we got the release of his statement in written form. After you had a chance to go over it, what stood out most to you?
Well, a few things. One is it's a longer version than his original statement, so it has a little more details. And really what stood out to me, and really what I'm going to go over really quick, is a lot of the stuff I thought was kind of bullshit by him in it. I mean, he had some points that are strong, but it's like, why, it's not an entertaining show for me to go through and say, oh, I agree with Nick Khan that this is correct. But what is interesting is the stuff I thought was misleading or kind of bullshit, or I have no idea. So to briefly go over some of them, he did, and he said this on during the hearing. He brought up that in 1980, Sugar Ray Leonard earned $8 million for a single fight, right? More than any baseball, football, or basketball player made that entire season. But he didn't bring up this part, which is the next part of his statement. Is in 1988, Mike Tyson earned more in purses than the entire roster of the Los Angeles Lakers and the Boston Celtics combined that year. And then he notes, talent follows money. The best athletes in America chose boxing because boxing rewarded them best. And so this is all accurate, right? This is true. But the only thing I read this is I'm thinking, this is the complaint against MMA, isn't it? That because you're not paying your fighters enough, we're not getting the best talent. And right. The $8 million that Leonard got back in 1980, and he was not the highest paid boxer that year, that wouldn't be reached until Brock Lesnar for a single fight in 2016 for a massive UFC 200 event. So, if you know combat sports, I did not think that was a very strong argument by him. Even though it's truthful, it's accurate, but it seems when you see what you've done with the UFC, the complaint from a lot of fans is that talent is no longer coming because the money's not there. It's like, well, I don't know if this is the best pitch you can make, but lucky for him, I got a feeling that people in the Senate have no clue what's going on in MMA. The other thing he brought up was that I commented on this earlier, but it kind of drives me nuts. He pointed out that the very first findings in the original Ali Act was that professional boxing differs from other major league interstate professional sports industries in the United States, and that it operates without any private sector association, league, or centralized industry organizing to establish uniform and appropriate business practices and ethical standards. And that's accurate. That is the very first finding in the Ali Act bill when it was passed, the Senate in 1999. Before it was signed in 2000. And so that's accurate, but that's a finding about he reads it off as if that's the problem with boxing and that's the part they need to fix according to the Ali Act. But no, that's the finding. That's a description of the situation. Because the very next finding that they have that he does not read, you notice, is that state officials are the proper regulators of professional boxing events and must protect the welfare of professional boxers and serve the public interest. But he's kind of saying that's, in his vision of the UBO, that's the primary way that boxing will be organized. And they're saying state officials have to have an oversight over this. And then it goes into how the other finding was that promoters who engage in illegal, coercive, or unethical business practices can take advantage of the lack of equitable business standards in the sport, right? And well, what do you think the UBO
That's kind of ironic, isn't it?
Yeah. They want to introduce coercive contracts. They want to introduce the provisions that this was there to kind of level the playing field. It also says that open competition in the professional boxing industry has been significantly interfered with by restrictive and anti-competitive business practices of certain promoters and sanctioning bodies. Now, he tries to claim that they're a pro-competitive bill, but you are doing all the things that limit competition, according to the previous Ali Act. So none of that really, to me, added up that much, that well. So that caught me. He also noted in it that a UBO is not a governing body. Okay, that's kind of true, but you're also kind of claim it's a league. And if it's a league, then who's the league governing body? And if it's, like the NFL is the governing body for the NFL league, the National Football League. NBA's, the NBA entity itself is the governing body for all the teams. And if you look at a UBO, what does the UBO do? It's in charge. This UBO is going to have its own drug testing. Well, that's a that's generally a regulation that's put on the commissioners, right? The athletic commissioners, they're taking that responsibility themselves. This UBO gets to dictate which fighters fight which and where. This UBO gets to rank fighters, determining where they are in the rankings, who gets a mandatory title shot, who gets a chance to be the champion, who retains their belts. All those are functions of different bodies than in current boxing. And that's, basically when you think of a league structure, that's the league structure is the parent company. The difference is a league is made up of multiple teams, right? And so as he notes later, if they have a UBO for the first time, both boxers and fans would have the option of a centralized organization that can establish uniform standards in the crucial area, including safety and anti-doping and anti-conflict of interest rules, and create conditions by which boxers can thrive. Okay. But again, he brings it up as like it's a competitive version. But where's the competition? It's not 30 teams in the NBA, right? It's one team, your UBO, that is dealing with the players. It's a single entity structure. So it's got a lack of competition, and yet it would still be a league, air quotes there. And even though it says it's not a governing body, they're the ones dictating all the terms that a traditional governing body would. So that caught me off guard. The other one was he went through the provisions. I thought was interesting. He highlighted all the things the Democrats, I think Ilhan Omar introduced herself specifically, but I don't know if she was the only one behind these, but these were the Democrat introduced provisions. He highlighted all of them as positives, but some of his stuff seemed to stretch because he noted a 6-year cap on promotional contracts, which is roughly comparable in duration with rookie contracts in Major League Baseball, the NFL, and NBA. That would end the practice of binding boxers to promoters for their entire careers and give them a genuine path to free agency. And holy crap, is that bullshit? Because if you read the previous testimony, the previous hearings, the previous reports, the ALIAC, 6 years is the entire duration of a career, boxer's career. The original report, the standard for a boxer's career is they called like the prime earning areas. Some boxers have longer careers, but like for most boxers, what is the duration of your career and the prime earning potential was considered 5 years. This is a year longer. On top of that, he hails it and compares it to the other leagues. The rookie contracts, the major leagues are negotiated as part of the collective bargaining agreements. They have set rates much higher than the boasted about $200 per round rate that they have. They have set rates dictated by a negotiated collective bargaining between the Players Association and the league, because the players are giving up their right to go to any team and have massive bidding wars over them. In exchange for other benefits given to them by the league. So it's a trade-off, which is very beneficial to the players. And it's not one where you're trapped in a shitty. I mean, it's a shitty contract for some of these guys are trapped in shitty contracts for pro standards, but it's still multiples upon multiple. I mean, just infinitely better than the 6-year cap you could be if you're getting $200 a round or something ridiculous like that. This is the other one he brought up: the right for boxers to contract other promoters in the final 30 days of a contract. Which that was added by Omar, I believe. That was one of the ones she added. Which, it doesn't really, I don't think it would do much. But then he adds the comment: a right that exists on paper under the current system, but has rarely been granted to most. And I read that, and all I could think of was, what are you talking about? I've never heard of that. What current system has that provision? It's not in the current Ollie Act. It doesn't exist at all in that. I couldn't find it in any state boxing regulations, so I didn't know where the hell he got that idea or what that's from. I could be wrong, but I don't think I am. I don't think this is it. I don't think that provision exists in the current structure anywhere else as pre-existing. And so the final note I will go on is that he brought up that the Muhammad Ali American Boxing Revival Act does not seek to eliminate competition in boxing. Rather, it seeks to create the condition under which genuine competition can flourish. The UBO framework is open to any qualifying promoter. Multiple UBOs can exist. Promoters, including Golden Boy, Top Rank, and MVPW, could each form a UBO. Any organization willing to meet the boxing protection standards in the bill is eligible. This is not a bill written for a single company. It is written for a sport. And Okay, let's take him for that.
What
word on
about
that.
those hurdles that prevent all those other companies from doing this?
That's why I think they're in it. But let's pretend those hurdles are not really big hurdles. Let's pretend all these promotions can do this. What, per se, are you fixing then in boxing?
Mm-hmm.
The problem you mentioned earlier was there's too many titles. Now you're talking about not just the 4 sanctioning organizations that could still exist, because it's not rewriting the bill, it's offering an option. So there'd be 2 systems that would exist, the 4-belt era place and the UBO. But now you're saying every promoter can have their own championship. Well, that's a shitload more, and there I am already giving away the free swearing, a shitload more of titles you just introduced if every promoter does it. Also, where is the competition? You've complained that we're not getting the big fights. We are not getting the unified single champion that everybody accepts. Well, again, you're going to have tons of belts, and all these boxers are going to be signed to other promotions who can engage in practices like coercive contracts that don't have to honor mandatories. And so you would basically eliminate cross promotion. Co-promotions would end, fighters being able to jump around. And so where would the increased competition come from? You're limiting it with this system, and on top of it, you're entering a bunch of belts. And so the only way it works, the only way this achieves what they claim on one hand, what they want to have is, which they're saying is, we want one title that the fans and the boxers care about, and all the fighters are kind of compelled to fight. Well, that only works if there's only one UBO, at least one UBO of scale. And so this pitch here tries to seem to have the best of both worlds, and it doesn't really make sense at all. And so that was his statement. The only other thing was interesting. They had a whole breakdown of the tickets that the WBC bought for the Canelo versus Crawford bout, which I think the whole point was to try to embarrass them that they spent $263 on tickets. But it was also somewhat confusing. He made this whole thing how they're just ripping off boxers, but and that they always expect these freebies. But he's pointing out here that they bought the tickets, so they're ripping off fighters, but they're also still paying for their own tickets. They're not demanding free tickets. And listen, I don't want to defend the sanction organizations, because fuck knows I have tons of problems with them. But here it just seemed like a mixed message, that on one hand you're arguing all their problems, but then pointing out they can spend $263,000 on tickets. Yeah, but they did buy the tickets with their own dollars. They didn't demand freebies. That's the part I was a little confused about, what he was trying to get there.
Mixed messages. That's the king there. All right, let's move on a little bit, but this is still related. Lou DiBella was recently on Ariel Helwani's show, and he said the following: it's not going to be just hobos that are signing with TKO. It's not going to be very long before they're going to have a roster that compares favorably with every single other promoter. And the key here being, it's not going to be very long. Do you agree with him? To access the bonus content of this episode, you must be a paid subscriber. To do that, go to heynottheface.substack.com and subscribe today.
Ow! Ow! Not the face! Ooh! Ooh! Okay, the face!